All right, folks, you may notice a different background for me today. I am officially in the process of packing the house, so you may see me in a number of different rooms over the course of these next few videos. But as I come to you today, I wanted to get started talking a little bit about the judicial system, the judicial branch. And I put two chapters in this week, civil rights and now the judicial branch. Why? Well, it takes a lot of guts when you think about it to create the civil rights that we've talked about. We've talked about group identifications. We've talked about the idea that, all group identifications, regardless of who or what it is that you are, you should be treated equally before the law. Now, here's the thing. When you go about establishing rights for groups that have never had rights before, it actually takes an awful lot of guts. Elected officials are not going to be inclined to make these kinds of decisions. Why? Because the next time that they are actually up for election, reelection, the voters are actually going to have a chance to go to the polls and hold them accountable for things that maybe, in fact, the majority of the population don't necessarily view as appropriate. So, who can make this decision? Well, oftentimes it's going to be the court system. And depending upon where you are, depending upon what level of the court that you're talking about, what you'll see is that, I mean, at the federal level, judges are never voted on by the general public. They are nominated by the president, they are confirmed by the United States Senate, and then they serve for life. So they don't necessarily have to worry about what people think of their rulings. What they're supposed to be focused on is making sure that their rulings are right, that they're legal, that they're constitutional, irrespective of what the politics are. And let's face it, y'all, if you're an elected official, you're always going to be concerned with the politics. So as we get going today, let's get started with this a little bit and let's talk a little bit about the judicial branch. We're going to jump ahead to chapter 13 and bear with me as I juggle my screens for just a second. I've got a couple of videos today that I'll work into here, and we'll talk a little bit about the idea that even though the courts are not supposed to be political, guess what? They probably are more than we would want them to be. Just to give you some miscellaneous stuff here at the very beginning today, and bear with me as I juggle my screens just a little bit. You'll notice up here this big number, 100 million. And this 100 million number, if you take all of the local court cases, if you take the state court cases, if you take the federal court cases, and you add them all up in the United States, there's over 100 million cases every year. Now, if you wonder why, you get a ticket and you don't go to court for 6 weeks, and I'm talking about a speeding ticket or something like that. If you wonder why it takes so long to get to court, if somebody has been accused of a crime and maybe at some level they victimized you, it's because of this overwhelming number of court cases that go to court every year. I mean, this is basically saying that one out of every three Americans, we have over 300 million. If there's 100 million cases, that's basically saying that one out of every three Americans is going to be involved in court every year. And when you figure oftentimes that there's party on one side and a party on the other, there's a plaintiff and there's a defendant, you could maybe argue that that number even goes up. So that's kind of a scary thought. And that doesn't even include the specialty courts, which I'm not going to focus on just because I don't want to get into too much minutia. But I bring this up to you, the idea that there are easily over 100 million cases every year, and the vast bulk of these never ever even get to court. They're filed. So you can see why the court is backlogged, even if, say, 90% of these are plea bargained out. It's still 10 million cases, and that's still a lot of decision making to actually render. I'll start with judicial federalism here as we get going. And we've talked about this idea of, federalism, the idea that there is a state and a local division of power. There is a state and federal division of power, this kind of a thing. Well, there's a division of power between the courts too. Just like all of the branches, they did not want the courts to become too powerful. So what did they do? They effectively cut half in half. And what I mean by that is that you think about it, we've divided things up into federal and state cases. So there is a federal court system, and then there are state courts as well. Now, understand on this, the Supreme Court may be the highest court in the country. I'm not going to, dispute that. But that doesn't mean that every single case goes to the United States Supreme Court. There's got to be a constitutional question that's involved. There's got to be an issue of federal law that's involved. If one of these two circumstances is met, well, then the Supreme Court is actually going to be the court that has the final jurisdiction. Now, the trick on this, though, is that, let's face it, there are cases that are just going to deal with state laws. There are cases that are just going to deal with state constitutions. So, as such, if you file in state court, and there isn't a federal law and there isn't the Constitution that's at stake, then in fact the state Supreme Court would be the highest ruling authority. So keep that thought in mind. And when you figure that there are far more state cases than there are federal ones, that would mean that the state Supreme Courts, or the highest courts in an individual state, are actually going to have authority, final authority over more cases than in fact the United States Supreme Court will. Now, basically, and I'm going to generalize here just a little bit, but there's three levels of court, and maybe you've heard that quote, I'll have my day in court over this, or I'll fight you all the way to the Supreme Court if I have to. Well, that may very well be. But there's three basic steps when you deal with courts. There's the trial court step, there's the appellate court step, and then there's the United States Supreme Court step. And we're talking about federal cases here for now. If you go to a district court in the United States, the district court is basically going to be the trial court. Okay. It's going to be the trial court. And this is where you see the attorneys present the evidence, you see the questioning of the witnesses, these kinds of things. The judge is not supposed to be the active player, but in fact, in our adversarial judicial system, it is lawyer versus lawyer. And you will hear judges say over and over again, my job is really just to call the balls and strikes. I'm not the one throwing the pitches. I'm not the one hitting the ball. I'm the one just calling the balls and strikes and keeping the game going, enforcing the rules kind of a thing. Trial court is where a lot gets done. But it's, again, this step that you see maybe glorified or criticized in Hollywood, in media, the attorneys, the presentation of evidence. You get the idea. If you get to an appellate court and, you've got a right to a trial court, you have a right to appeal too. And if you take it to the appellate court, they are not going to be dealing with witnesses and presentation of evidence. When you file an appeal, you are typically filing an appeal because your rights were violated. Now, you might think that the court got the decision wrong, but this is really about process when it gets to the appellate court. Was evidence admitted that shouldn't have been admitted? Was evidence omitted that shouldn't have been omitted? These kinds of things. Was there something procedural? Was there something about evidence that both sides didn't have in a timely fashion? Well, the idea is in the trial court, you're basically going to make your arguments. In the appellate court, you're going to make the arguments about your due process, the idea that everybody was treated fairly by the court, the idea that the judges made the right balls and strikes calls in order to keep the process moving in a fair manner. Now, you have the ability to go to court. You have the ability to appeal. There is no guaranteed right, y'all, to actually get to the United States Supreme Court. And depending upon the year, if they get to 100 cases that they actually make a decision on, it's a good year for the Supreme Court. And that's basically saying 100 cases out of 100 million plus possible examples. Those are hella bad odds. I mean, let's just say it, to get to the United States Supreme Court. So with this in mind, the Supreme Court gets to pick the cases that it wants to hear. Oftentimes, state Supreme Courts will be able to do the same. And if they do not accept a case for review, then effectively what that means is that they are rubber stamping, if you will, the lower court decision that in fact they got it right. Whether it's the facts, whether it's the procedure, whether it's the due process, whether it's the whatever, they are basically saying that it's okay. Now, a couple of other things. And, talking about judicial federalism, let me get into this idea about how judges actually will become judges. Now, you'll notice up here appointment. And I mentioned to you the idea that in the federal courts, the president will nominate, and this will be subject to the advice and consent of the Senate. Now, understand on this, the House of Representatives has no role. The president will nominate, and the president can oftentimes nominate whomever the president wants, although they may very well work with local federal senators, to make sure that they're in the good graces of the vacancy, the area where the vacancy is taking place. But understand on this, the House has no role, and these folks are appointed for life. So, once you make an appointment, president might serve in office 4 years or maybe two terms, 8 years. But the judges that they leave in office could conceivably serve 20 or 30 years. It doesn't matter if you like Trump now. It doesn't matter if you like Biden a few years ago. It doesn't matter if you like Barack, or George W. Bush Jr., Junior Bush. The idea is that these folks still, when I go back to Junior Bush and Barack and Joe Biden, they still have judges that are in office. And in some instances, it's been over a decade, pushing 2 decades since, in fact, they were last in office. So this is a very significant power for a president, and it's a way to leave a lasting legacy. Now, at the state level, there will still be governors that will appoint judges. But let me say this regarding the appointment process. Sometimes judges can, or pardon me, governors can just appoint judges with the advice and consent of their state senate. However, there are a number of states that have moved to remove politics from this process. And what they will actually do is they will create what's known as a blue ribbon panel, members of the bar, maybe retired judges, maybe some lay people from the community, academics, and things like this. And these folks will actually pick 3 or 4 or 5 names that then the governor will go to. And while the governor has the final choice over who gets a nomination, it's actually the blue ribbon panel that puts together that 3 or 4 or 5 most qualified people from the governor to pick from. This is considered less political because it's not just in the hands of the governor. It's not just in the hands of, say, the state senate, but in fact, it's in the hands of people, the Bar Association for lawyers, retired judges, lay people, and academics in the community that maybe best know what a judge should be, at least more than what their politics are. Now, let me give you another one. And I want you to think about what Maryland does with state judges. What Maryland does is the governor will actually be able to nominate a judge from one of these blue ribbon panels. However, the judge will serve an abbreviated term, maybe for a couple of years, and then they will have a yes vote election as to whether they can continue. So they won't actually be like voting between, voters won't have the ability to pick other judges or other potential judges at this point. But what they will be able to do is they'll be able to vote yes or no that the sitting judge with this temporary term could continue to serve as the judge. And if they vote yes, then the person will now serve a term designated that is depending upon the state, maybe 6, 8, 10 years. Well, if they vote no, then all hell breaks loose because pretty much anybody, if they can get some signatures, can end up on this ballot. And then at that point, and file the appropriate paperwork. And then at that point, you don't really know who the judge is going to be. And let me say this, if I'm an elected official running for office, I'm a campaign, right? I'm going to campaign. Well, if I'm a judge, I'm supposed to be impartial. I'm supposed to be unbiased. I am supposed to go into every case without the public knowing how I'm going to vote. But if I'm campaigning for office, How can you campaign and maintain this idea that you are not going to vote a certain way or you don't have a predisposed position in your mind? It's a really hard thing to do. And if anything, to me, it seems like this opens up politics even more than if it was just the governor making the appointment by herself or himself. So understand when I say appointment, election, or now with Maryland, appointment and election, boy, golly, this gets really, really confusing. Now, let me show you something and give you something else to think about. We're going to talk about this a little bit more when we get into the Congress chapter. This other piece that I wanted to give you is this idea that's known, y'all, as diversity. Okay. Who should actually be the people that make up the judges that serve on the courts? Whether we're talking about state courts, whether we're talking about federal courts, whether we're talking about trial courts, whether we're talking about Supreme Courts, who should it be? There are a number of folks out there that would actually suggest that the people that serve as judges should be the people, in fact, that will best reflect what our population is. Now, like I said, I'm going to talk more about this when we get to Congress, but you could make an argument that if our country is over 50% women, and it is, then in fact, maybe we should have at least 50%, if not more, of our judges be women. If the Hispanic demographic is almost 20% of our population, then maybe 20% of our judges should be Hispanic. Maybe in that roughly 15% area for African Americans. Maybe 15% of our judges should be African American. So the idea is you want to see a reflection of the country and the people that are making the decisions. And y'all, I'm gonna be honest. I mean, my group identification, I'm a middle-aged white guy. I think I got a pretty good heart. I think I got pretty good common sense. But am I going to understand what a woman goes through on a day-to-day basis as a man who has never been a woman? Am I going to understand what a person of color goes through? Am I going to understand what a person that is different from me experiences if I've only always been me? And maybe, in fact, I've never, experienced the things that people say. So you could make an argument that maybe diversity, this reflection idea, is important. Of course, you could also make a pretty strong argument that what we really should want would be the most qualified people as judges. Now, I got to be careful here. I'm not saying that people that have traditionally never been judges cannot be effective judges. But what I'm saying is that when you think about daily life, oftentimes the people that have the most experience doing things get the best opportunities to do them going forward. And who is it that has been judges more than anybody? Well, been white guys, right? So, do you want the most qualified in terms of what they can put on a resume? Or do you want the person, I'll put it in a really simple way, that's most like you? Because it stands to reason that if somebody is most like you, then in fact, guess what? They're probably going to be able to make decisions that would best consider your circumstances. Now, you'll notice page 508, page 509, and I wanted to show you this table right quick, and you can take a look at this as you look at the text. But you'll notice up there, there's Joe Biden. Joe Biden by far at the top, even more than former President Obama. 46% of the people that he had nominated to be judges were Black, Hispanic, or mixed race. And this is as of October of 2024. So I'm sure he made a few more appointments. You'll notice up there it was 82 white, 54 Black, 31 Hispanic, 27 Asian. You get the idea on this. You look at President Trump from his first term. 7% of the judges, in fact, that he appointed were Black, Hispanic, or mixed race. That means that, Biden had appointed maybe 7 times more people of color than, in fact, for President Trump did in his first term. I would think that in President Trump's second term, he probably didn't change a whole lot so far, and I don't expect him to in the remainder of his term. Now, understand on this. Even Barack only got to 36%. And you notice down there, Bill Clinton for a very long time was known for his kind of rainbow coalition, if you will, with his cabinet and judge appointments, he was even only at 24%. So the numbers, when you go back in time in the last 20, 30 years, there are some very dramatic differences between what Democrats appoint and what Republicans appoint. Now, I'm not going to sit here and say one way is right or one way is wrong. I'm just going to say these patterns are the realities. And I'll leave that to you to decide as far as what's right or as far as what's wrong. But let me show you something else. And I want you to think about this in the context of politics. When you think about current President Trump, who was it that most likely voted for President Trump? It was, white Americans, white men oftentimes. And so it stands to reason that politically, if these are the folks that put him into office, then these would be the folks that he would reward for voting for him. Now, let me juggle my screens here for just a second and let me show you Vice President Kamala Harris. And this is actually, and again, bear with me as I juggle my screens, this is actually going to be from the night that they began to acknowledge that they had won the election. And this is going back to 2020. And this is out in a parking lot. I mean, this was really thrown together pretty quickly. And you'll hear horns blowing and different things like this. Let me make sure that I've got my sound on so that you can hear this. I'm going to run this for a couple of minutes. And this is Vice President Harris. Really, the big thing that she had done in this speech was to say a lot of thank yous to her family, to President Biden. I'm going to pick this up as she talks a little bit about her mother and then maybe begins to transition into some of the politics behind what would become Biden's judicial appointments. Let me go ahead and run this for a couple minutes.
And to the woman most responsible for my presence here today, my mother, Shamala Gopalan Harris, who is always in our hearts. When she came here from India at the age of 19, she maybe didn't quite imagine this moment, but she believed so deeply in an America where a moment like this is possible. And so I am thinking about her and about the generations of women, Black women, Asian, white, Latina, Native American women, who throughout our nation's history have paved the way for this moment tonight. Women who fought and sacrificed so much for equality and liberty and justice for all, including the Black women who are often, too often, overlooked, but so often prove they are the backbone of our democracy.
Go ahead and stop it there. And, I brought this up, and let's be honest, if you want a country where the judges, where the system reflects the people, the Biden record that's mentioned there on page 509, those statistics, they're impressive because by far and away, that's the biggest amount of diversity that there's ever been. But is this out of the goodness of Biden's heart? Or was this done because these were the folks that ultimately put him into office? You can argue that Trump plays politics, and he absolutely does. I mean, he's an excellent politician. Whether you like his mannerisms, his ideas, whatever, his politics, he is an excellent politician. Biden, in making these appointments, was rewarding the people that had voted for him as well. So this wasn't just the idea of let's create something that reflects ultimately the country. He was putting people into office that reflected the people that put him into office. So when we say this idea that these judges, it's supposed to be apolitical and they shouldn't have to worry about elections, well, they don't. It's not that the politics occurs with judges after they make the decisions. It's the politics occur with the judges as they get put into office. Now let me move real quick, and I'll keep going here, and let me juggle my screens for just a second one more time and get back to the outline. And as you look at the outline here, a couple more things before I cut this off, because I do want to show you a few other things today in a second video. But you'll notice up here just a couple of things talking about a little bit of history. And I'll be fairly quick with this. Maybe the most important case in terms of the power of the Supreme Court. Now, you can argue, and we've already talked about Dred Scott being the worst case, in American history, whether you're talking about how it viewed, the slaves at that point, or whether you talk about it leading directly to the Civil War. The case that was the one that was definitely the most powerful for the United States Supreme Court development was Marbury versus Madison. And you'll notice in here, there is that term judicial review. Now, let me stress this to you really quick, like as I make mention of this. Judicial review is nowhere at all mentioned in the United States Constitution. There was a Judiciary Act of 1789 that was passed. There was a Judiciary Act of 1789 that was passed at the very end of John Adams' presidency. And when this Judiciary Act was passed, it actually did an incredible amount of good things regarding the courts, regarding the creation of courts. Now, the problem that came with this is that as they created judgeships, John Adams, the president who was leaving office, he forgot some of the appointments that were remaining on his presidential desk, which means they never got delivered. Now, who do you think John Adams was appointing? John Adams was appointing good Federalists, the kind of people that would have voted for him, but also the kind of people that, in fact, did not win the election because John Adams was beaten by Democratic Republican Thomas Jefferson. So Thomas Jefferson came into office, y'all, and he saw these commissions. Do I deliver these commissions? Are they valid commissions? They've been signed, they've been sealed, but they haven't been delivered. Thomas Jefferson said no. So Marbury, one of the people whose commissions did not get delivered, decided to sue Secretary of State James Madison because it was his job to deliver this. Well, in the case, everybody knew that if John Marshall, who incidentally was the Secretary of State under John Adams, that did not deliver the commissions, boy, that's a conflict of interest if I've ever heard one, right? He wanted to make a little bit of an example to Jefferson. There was a sense that John Marshall would be somebody that would help keep the Federalist voice in the courts, even if they weren't going to be the majority in Congress or the sitting president in the White House. So John Marshall, this justice, there was a sense that he was going to try and make Jefferson deliver these commissions. But everybody knew that Jefferson was not going to do it because nobody really knew what the power of the Supreme Court was. So what did John Marshall do? Knowing that politically it would really basically castrate the Supreme Court, John Marshall struck down the Judiciary Act of 1789, at least the part of it that dealt with requiring a Secretary of State to deliver a commission. He said this enlarged the original jurisdiction of the Supreme Court. You would have to go back and start in the lower trial courts and not jump all the way up here to us. And this was the establishment of judicial review. Now, like I said, the Federalists were not exactly happy with John Marshall because he didn't get the commissions delivered. But while he lost the political battle, you could argue he won the political war because he established the power of judicial review. It's emphatically the province of the court to say what the law is. And if a law of Congress, in fact, contradicts with the Constitution, then in fact, it's the Constitution, because it's the court that says what the law is, that wins. And they struck down the Judiciary Act, again, the part that was dealing with writs of mandamus. Now, again, it's not mentioned anywhere in the Constitution, What you'll see, y'all, is that every time there is a nomination to the United States Supreme Court, there's a hell of a fight. Why? Because again, if I'm a president and I can serve 4 years or only 8 years, right? Then the fact is that my judicial nominations, especially to the federal courts and the Supreme Court, could be there 20 or 30 or 40 years, maintaining my mindset in office long after I'm gone. And because this partisanship has increased in the courts over time, what you'll notice on here is there's been actually a very dramatic increase in I guess the frequency with which judicial review has been used. Now you'll notice in here, and this is on page 513. You'll notice in here that really Golly, for the first, I don't know, several hundred years, not several hundred years, but over 100 years, there were only maybe about 20 cases that were struck down by the Supreme Court. This has jumped dramatically over the course of time. They are striking down acts of Congress. The Supreme Court is becoming much more active, and it doesn't matter if it's got more of a liberal majority or more of a conservative majority. They are active on cases that maybe strike the closest to their particular hearts. This is part of the reason why the Supreme Court is losing some faith, because it doesn't look like it's above politics. It looks like it's mired in politics. And to be honest with you, when politics dominates this appointment process at the beginning of a judge becoming a judge, it stands to reason that it's only going to permeate their decisions. Politics will when they get there. Now, let me give you three quick things here to think about. And these are types of law. Now, I know that this is going to sound crazy. Legislatures try and pass laws that deal with many kinds of conducts. They can't possibly get it all passed. And sometimes what you'll see is that it's not a legislature that declares something that's actually legal or illegal. But in fact, what you'll see is that it is a court decision that does so. And common law is what is known as judge-made law. Judge-made law is basically sometimes judges will issue rulings on cases where there is not a clear law that was passed by local government, state government, federal government, and now this becomes judge-made law because the judges say it. Now, could a legislature come back and or something state or local come back? Could they actually pass a law that would be contrary to the judge? They could, but oftentimes they don't. And we have a very strong and rich common law tradition in the United States. We do it this way because the judges said so. We do it this way because we've always done it this way. We've done it this way so long. We're just going to keep right on going forward into the future with it. Now, then there's civil law. Civil law is a little bit different. Let's say that this is a situation where you're in a car accident and you get injured. Somebody is going to get a ticket in that car accident. That's not civil law, that's criminal law. But if you're injured and you decide that you're going to sue for damages, maybe for wages or medical bills, wages from lost work, things like this. Well, this is an individual suing another individual. That, y'all, is what civil law is. And civil law has got a lower standard of proof. Why? Because there's a sense out there that protecting your property or the accused's property in a civil law case is a little less important, maybe a lot less important than protecting the freedom or the life of someone who is engaged in a criminal case. Now, in a criminal case, it's a little bit different because this, again, going back to that car accident, if there's a car accident and somebody gets a ticket, well, that ticket is going to be the state versus so and so. This is going to be government versus an individual or a group of individuals. And in criminal law, it requires the highest standard of proof to determine somebody as guilty. Why? Because understand your freedom or your life are going to be, again, valued higher to the founders anyway than in fact your wealth. Now, I may have mentioned this a little bit earlier, but if you remember, O.J. Simpson, O.J. Simpson was charged with murder and cutting off the head of his ex-wife and killing her young lover. But the standard of proof was so high that it was never attained. So he was not convicted. Now, when he went to civil court, because the case was lower and because this was about resources, money, economics, well, the standard was lower. He did indeed lose there. In criminal law, you're innocent until proven guilty. In civil law, there's not that standard. You just need a little bit more evidence in favor of something than against to be able to render a judgment. I will stop there, but understand while criminal law is very important and while civil law is very important, especially in the United States today, don't underestimate common law because judge made law has been here for a very, very long time. Y'all, I will stop there and I'll be back to you in a minute.